Hello everyone, in today's video we are going to understand the format of petition for judicial separation. Alright, this is the format. You can download this format. The link is given in the description. Alright, so today we are going to understand this format. First of all, let us understand few things. Just a second. Alright, so whenever, let's say there are two party, husband and wife, alright, and they are married, but due to certain situation or circumstances it is not desirable for both of them to live together, alright, because of certain circumstances that has been arising. Alright, so for that, now party wants to file divorce in court. Alright, but court on the first instance does not provide you divorce. Alright, if husband wants to file divorce or wife wants to file divorce, until and unless they are mutual divorce, they decided to take divorce mutually. Alright, that is a different case. But if any party wants to get divorce, alright, which is not mutual, court will not at the first instance allow divorce. What court will do? First of all, court will allow judicial separation. Alright, judicial separation for certain time. During that time, husband and wife will live separately. Alright, they will not interfere in each other's life and they will not have any right on one another for certain time. Alright, so even at this stage, at the stage of judicial separation, there is no divorce. Still he is husband, she is wife. Alright, but they have no certain rights or duties for certain time. What is the purpose of judicial divorce? The purpose of judicial divorce is to provide time to husband and wife, alright, to understand the importance of marriage, alright. So that is why, there are certain time you got angry on certain things or certain circumstances, but after certain time you realizes that okay, that was not that much huge kind of act that can lead to divorce. Alright, so that is why court on the first instance allow time so that husband or wife can realize the importance of marriage. Alright, they can realize importance of each other in their own life. Alright, that is why court allow judicial separation. And if, let's say, court has allowed judicial separation here, alright, and after certain time husband and wife realize that they do not want to get divorce. Alright, they do not want to get divorce because the time has lapsed, and after that time the husband and wife realize that divorce is not a good thing to do. Alright, it is not a valid thing to do. Alright, so even after judicial separation, when the time lapses and husband and wife does not want to get divorce, the court will not allow divorce. Alright, court will make an order that husband and wife will live together, alright, and marriage will continue. But even there might be a situation when even judicial separation has been allowed for certain time, alright, and even after that lapse of that time, husband and wife still does not want to live with each other. Alright, in that situation, court will allow divorce. Alright, court will allow divorce. There will be certain proceeding that will going on, and after that court will allow divorce. Alright, so we are going to understand how the person, whether it is he is a husband or wife, how they can file the petition for judicial divorce. Alright, so let us understand this format. First of all, you have to mention in the district court at. So jurisdiction belongs to district court. Alright, you have to understand this. Whenever there is a case related to divorce or judicial separation, the jurisdiction belongs to district court of that area. Alright, where the party resides. Then petition number and the year. In the matter of, you have to mention the name, residence of, son or daughter of. Alright, whoever filing this petition, you have to mention at the right hand side, represent it, petitioner. Same in the case of respondent. Alright, then the subject come. What is the subject? We are filing judicial petition for judicial separation under section 10 of Hindu Marriage Act. Alright, now here I want to tell you something. For example, we are talking about Hindu Marriage Act. Alright, for that purpose, both husband and wife should be Hindu. Alright, belongs to Hindu religion. But what will happen if there is husband and wife? Husband belong to Hindu, alright, wife belong to any other religion. Alright, there might be a situation. This might be a situation. Then what will happen in this case? Then Special Marriage Act will apply. Alright, Special Marriage Act will apply. Or under that act, there is also judicial separation. The concept of judicial separation is given. Alright, so you just have to change this subject, alright, according to the desired section of that Special Marriage Act, if party belongs to any other religion. Alright, then you have to mention points. The petitioner is filing this petition, then petitioner has to mention the points. What are the points? That marriage was solemnized between parties. You have to mention the date and the place at which marriage was solemnized. Alright, after that you have to mention that the certified extract from the Hindu marriage register affidavit duly attached therewith, because whenever it is not mandatory, alright, whenever there is marriage under Hindu Marriage Act, you can also register your marriage. Alright, although it is not mandatory. Alright, so if you have registered the marriage, you can also attest the affidavit, alright, and the certificate. You have to mention the affidavit that the certificate is extracted from register, alright, Hindu marriage register. After that, what you have to mention? The status and place of residence of the party. Alright, so you have to mention that before marriage, husband and wife, the residence of that husband and wife, where they lived. Alright, and after that, after the filing of this petition, husband and wife, their status, their age, their place of residence, you have to mention all of this. So you have to mention both before marriage and after marriage. Alright, you have to mention these details. Then next paragraph come, in which you have to mention the particular and place of cohabitation. Alright, if husband and wife are married, alright, they have children, then they must have cohabited at certain place. So where they reside, alright, the date and place of birth, name and sex of child, whether male or female. Alright, you have to mention all of these details. Alright, after that the next point come. Now here you will mention the ground on which you are asking for judicial separation. Alright, you are asking for judicial separation, then there must be a ground, so you have to mention the ground. Alright, if there is any offense, suppose cruelty is a ground, you have to mention that as well. If adultery has been committed, you have to mention that as well. Alright, you have to mention everything in separate paragraph. Once you have explained all of this, now what will happen? The next paragraph you have to mention that petitioner is not present in collusion with the respondent. Alright, so only this petition is filed, and other than this there is no collusion. You have to mention this. Next point will be that there has not been any unnecessary or improper delay in filing petition. Alright, so you have filed the petition in proper time. You have not taken unnecessary or improper delay. You have to mention this as well. The next paragraph will be that there is no other legal ground why the relief should not be granted. Alright, why you are filing this petition? To get judicial separation. Alright, and there is no other ground that why that relief should not be granted. Alright, you have to mention this. After that, you have to mention that if, let me just tell you, if there is husband and wife and there is any proceeding are going on, alright, any other proceeding going on, let's say P1, P2, alright, and then husband file judicial separation, the petition for judicial separation, then under this petition of judicial separation, husband has to mention that already two separate other proceeding is going on, alright, regarding any other matter but related to matrimonial, alright, related to marriage. So here it is, if there is no such proceeding going on, you have to mention that as well, that there is not been any previous proceeding with regard to the marriage. Alright, and then you have to mention that if there is any proceeding, you have to mention the details of those proceeding. Alright, and what are the results of that proceeding. Once you explain that, then you have to mention that marriage was solemnized at the place. You have to mention husband and wife, where they reside. You have to mention any one of these. Alright, because why you are showing this? Because you are telling court that court has jurisdiction. Alright, and court has jurisdiction in all of three cases. Where the marriage solemnized, court has jurisdiction. Where the wife or husband reside, court will have jurisdiction. And when husband and wife lastly reside together. Alright, so all of this will be under the jurisdiction of court. That is why you have to mention any one of these. Alright, then you have to mention your prayer. Alright, what you are praying for? You are praying for decree for judicial separation against respondent. Alright, after that you have to mention the petitioner's signature at the right hand side, then verification. Under verification you have to mention the paragraph that are true to your own knowledge and belief. Alright, you have to mention the date, place, alright, at which you are verifying this petition, then place, and at the right hand side petitioner's signature. So this is the format of petition for judicial separation. Alright, you can add certain other points according to your desired circumstances. If there is any other offense, matrimonial offense, adultery, you can change that scenario. Alright, in today's video that's it. We will meet in another video. Till then, goodbye.